I want to talk to you today about the term judicial pretrials in Ontario. Now, what is a judicial pretrial? When does it happen? Why does it happen? Well, first of all, a judicial pretrial simply means that the defense counsel and the Crown Counsel, the prosecutor, have a meeting with the judge. That meeting is to discuss the file, your client's file, with a view to A, either trying to reach a resolution of the case for a guilty plea, or B, trying to manage court time and talk about the trial issues. In many instances, judicial pretrials are required. For example, if your matter, you know it's heading to trial, you have to have a judicial pretrial in the province now. So the purpose of that type of judicial pretrial is managing court time. You're discussing with the judge witnesses that are going to be called, maybe some of the legal issues, charter applications, how long each witness is going to testify, and the judge gives his or her opinion about those issues, and you try and come to a decision. What is the estimate of court time? Say it's 1, 2, 3 days, could be weeks if it's a jury trial. In Superior Court, for example, we have to fill out a very complex form setting out all these issues. Now, one of the things you don't discuss necessarily at a judicial pretrial, if there's a defense you feel that's hidden within the file, you don't necessarily want to disclose it. Some defenses are obvious. I mean, it's assault. We all know the defense is self-defense, but I'm talking more about obscure defenses. Of course, within the judicial pretrial, we're often also discussing plea discussions. For example, let's say the Crown and I have agreed to a joint submission for no jail. We want to get it approved by that judge we're in front of, rationalize it with him, explain why we reached this decision, which may involve providing him or her with case law, all of the facts of the case, the background of our client. And the judge says, oh, I can agree with that. Because at first blush, it might be too light a sentence. But now that the judge understands, for example, that the Crown is a weak case, that's why we're agreeing to no jail, because it's a weak case. We don't want to go to trial because we still have risk of losing, but hey, we're very pleased with this. So a joint submission, if we reach that, the judge will hopefully approve it, which they usually do in Canada and Ontario. It's very rare that they go higher than a joint submission, but in some cases they do. Then we can go in front of that same judge to plead guilty if the client wants at a guilty plea and sentencing date, or we've decided to go to trial. Now we've completely managed the trial time. We reach out to the trial coordinator where the judge does his notes, sends them to the trial coordinator. We know it's going to be a 3-day trial. We know the basic issues. We know that I have to file a charter application at least 30 days in advance. So these are very fulsome discussions that happen with a judge. If it's matters heading to trial, by the way, you don't have the judicial pretrial with the trial judge. You don't want to bias the trial judge about a fulsome discussion. So that's a rule. So it's a totally separate trial judge. And sometimes these are required, especially on complicated cases. Sometimes we have several judicial pretrials to finally resolve the issues. It takes time. There's a lot of effort and a lot of thought goes into this process. So that's essentially what a judicial pretrial looks like in Canada and specifically in Ontario. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.